I would first like to thank Professor De Bruyker and his team for the invitation and for organizing this amazing conference. And I would also like to thank Philip for continuing to steer the Odysseus network as the leading academic network in the area of migration and asylum. Thank you. Several months ago, Philippe and I were exchanging emails in order to define the exact title of this panel. After considering several neutral options, we opted for a more provocative title, and I'm glad we did so. The title of the final plenary session suggests that in the past year or so, the court has been showing signs of passivism in relation to migration and asylum law. The aim of this introductory speech is first, to define the term judicial passivism, second, to identify examples of the court's passive behavior among the judgments which have been discussed in the preceding panels, and third, to put this in a more general context of the role and responsibility of the Court of Justice. The term judicial passivism stands at the heart of this discussion and calls for a precise definition. However, unlike the term judicial activism, which refers to cases when the judiciary oversteps its powers, judicial passivism has not been used in relation to EU law. Despite the fact that one might semantically consider judicial passivism as the opposite of judicial activism, it is my understanding that judicial passivism is just a subgroup of judicial activism. In this regard, I would like to put forward a definition of judicial passivism, which would apply to cases when the court is consciously not using its powers where it should, and thereby sending a message to EU institutions, its member states, and other political actors in the EU. Having developed this definition further, I have identified two types of judicial passivism. First, judicial passivism in its narrow sense would refer to cases in which the court chooses not to decide on the issue by declaring that it lacks jurisdiction. In other words, by identifying a certain situation as falling outside the scope of EU law, the court is not addressing the substance of a given case and is actively choosing not to act. Second, judicial passivism in its extensive sense would also encompass situations where the court is using its judicial role, but it does so in a manner which deviates from the teleological interpretation to which the court has accustomed us over the past decades of its adjudication. Significantly, in my view, judicial passivism in both its narrow and its extensive sense is the flip side of judicial activism, as the court's conscious decision not to decide or to decide in a strict, formalistic way. The judgments on the EU-Turkey statement can be viewed as an example of judicial passivism in its narrow sense. Here I start from the presumption that there is room for a different reading of the EU-Turkey statement from the one given by the General Court. Under this reading, also supported by the ERTA doctrine, the EU-Turkey statement would be considered an EU act. If so, by failing to fulfill its judicial function of reviewing the legality of the EU-Turkey statement, the General Court has actively chosen not to decide on the substance of the cases. The Court's passivism in these cases could have far-reaching effects, both for EU migration and asylum law and the future development of EU law in general. It enables the EU-Turkey statement to endure and for similar agreements to be concluded with third countries outside the scope of EU law and exempt from judicial review of the Luxembourg Court. In this sense, the Court's behavior could be explained as its desire to accommodate itself to political reality and the member states' intentions, without having to rule on the compliance with EU law. However, it is doubtful that avoiding to scrutinize the EU-Turkey statement can or should be reconciled with the judicial function. Giving a carte blanche to EU institutions and member states not only sends the wrong message, that it is all right to have your cake and eat it, but also ties the court's hands to rule on similar agreements in the future. It is hard to conceive that the Court of Justice in the appeal procedure would endorse this stance taken by the General Court and reduce its institutional powers by excluding a whole category of cases from its jurisdiction and influence. There are views that the Grand Chamber's judgments on humanitarian visas in X and X, as we have heard in the previous panel, represents another example of the court's passivism in the narrow sense. That is, that the court should have decided the case was governed by EU law, but it remained passive. The crux of the case, for the purpose of the discussion of judicial passivism, is that the court did not answer the questions posed by the Belgian court. Instead, it determined that the situation was not governed by EU law and that the provisions of the Charter did not apply. However, in the context of the discussion of judicial passivism, the judgment in X and X significantly differs from the judgments on the EU-Turkey statement. Unlike the court's formalistic approach in the judgments on the EU-Turkey statement, in X and X, the court cannot be accused of refraining from the discussion of the object and purpose of X and X's applications, of the visa code, and of EU asylum law in general. The court examined the inapplicability of the visa code on the applications for humanitarian visas made by the Syrian family, and it did this in a non-formalistic, teleological manner. There are divergent views as to the correctness of the court's logic. However, no matter which stance one takes, it is evident that by its judgment in X and X, the court sends a message to the EU legislators that an opposite conclusion would require legislative amendments of current EU asylum law. So far, I've discussed judicial passivism in its narrow sense. On the other hand, cases AS and Jafari can serve as a starting point for the conceptualization of judicial passivism in its extensive sense. As stated previously, an extensive understanding of judicial passivism would also encompass cases where the court accepts to decide the case, but it does so in a formalistic way, without taking into consideration the overall purpose and scheme of the relevant norms, the factual circumstances of the case, and the intentions of the member states as the masters of the treaties. I would like to argue that this is exactly what has happened in AS and Jafari. Here, the Grand Chamber of the Court made a visible effort to discuss the substance of the cases and elaborated its judgments with many, often technical details. Despite this, these judgments can be viewed as an example of formalistic interpretation. They disregard, first, the overall purpose and scheme of the Dublin Regulation and EU asylum law. Second, the factual circumstances of mass influx of persons on the Western Balkans route. And third, the intentions of at least those member states which took part in the organization of the route, including the member states linked to the dispute. All these arguments question the correctness and rectitude of the court's formalistic approach. In addition, even if we start from the premise that the court's literal interpretation of the Dublin Regulation is the correct one, its automatic presumption that the criterion of irregular crossing is applicable to this case is rebuttable, as has been pointed out by Advocate General Sharpston in her opinion, and is discussed previously by Advocate General Villajon in Abdullahi. However, it is no coincidence that on the same day as a judgment in AS and Jafari, the Grand Chamber of the Court of Justice issued another important judgment in Mengestöp. Here, the court limited the temporal effects of its judgment in AS and Jafari by declaring that the Dublin transfer cannot take place upon the expiry of the 3-month period after the asylum application has been lodged. In practical terms, the court's flexible interpretation of the 3-month period means that this period has expired for all the migrants who crossed the Western Balkans route in 2015 and 16, and that consequently Dublin transfers to Croatia are not possible for the vast majority of these migrants. The combination of the court's formalistic approach to the Dublin regulation in AS and Jafari and its flexible interpretation of the three-month time period in Mengestab has a twofold effect. First, it sends a message to all EU member states that they have to comply with a strict reading of the Dublin regulation, regardless of the factual circumstances. It also sends a message to the member states as legislators that the application of the Dublin regulation as it now stands leads to absurd and dangerous results in case of a mass influx. At the same time, it precludes any immediate dangerous consequences of the rulings by excluding their application for the majority of migrants who transited the Western Balkans route, thereby indirectly recognizing the humanitarian and political sensitivity of the cases. The court's ruling in Slovakia and Hungary versus Council adds to the equation the principle of solidarity by confirming joint member states' responsibility for the mandatory relocation of the agreed quotas of asylum seekers from Greece and Italy. In this way, all four judgments can be viewed together as the court's attempt to strike the right balance between competing interests and responsibilities in the EU. However, I see at least two problems in this approach. First, it is my belief that striking the right balance by delivering a package of judgments cannot make up for the shortcomings of individual judgments contained in that package. Second, there is no doubt that the judgments in AS and Jafari will have a strong effect on the future behavior of EU member states in case of a new refugee influx. It is inconceivable that the member states would again authorize and facilitate a new Western Balkans route in the case of a future refugee influx. To conclude, why has the court chosen to be passive in these cases? It is my belief that the reason for the court's passivism is not its incomprehension of law, but its view that EU political institutions and not the court should take over the responsibility to act. Whichever the reason, judicial passivism in both its forms of judicial silence or judicial formalism is leaving a strong mark on the future development of EU migration and asylum law. Thank you.